Just a brief about us. Annveshan is our business consulting entity where um, I head the consulting division, and Mythili supports me with our other team members who are there in this call. Shraddha, Vijay Simha, Aditya, and Aman as part of our consulting division. And we'll be happy to present this webinar where this is a hot topic that is, in today's times, and most of us are looking at creating, getting into estate planning activities. So the session spans um, in this fashion. We will be talking about estate planning and the aspects of estate planning through will and the private trust. And then we will take you through the components and the characteristics of trusts, that is private trusts. And we will also discuss few scenarios and the key aspects of the trust deeds. And then we will be open for Q&A session. And in the meantime, we will also come up with one or two polls in between for you to answer and for us to get more insights. And you can use the Q&A session Q&A tab for you to post your queries, and we will be happy to address those queries towards the end of this session. Yeah, with this, let's get on to the main aspects. So let's understand quickly the importance of estate planning. While we all are involved or into creating wealth through different ways, that is, it may be a business activity or professional activity or through employment. We all create wealth, or we are in the process of creating wealth. That is one aspect of our routine daily life, um, or so. That being the case, it is also equally important to structure the means or structure the vehicle in a proper manner, which will hold or which will nurture and grow these wealth once it is created. And that is the crux of the estate planning that we all should understand. So let's understand what are the importance of estate planning. One is it's a mechanism for wealth to devolve in the family or within the family. What does that mean is post the lifetime of a person, how the assets, different assets that the person has created should devolve to the family. It's one of the important aspects that everyone should be aware of, or everyone should have worked upon. The next importance is provides for dependent family members in their future needs and care. So the point here we are trying to emphasize is, for example, the children needs educational support, the support for their education, higher education. They would want to travel overseas. So how can I help achieve those things by managing my assets appropriately and allocating into different buckets or bucketing these assets that we create for these different purposes. It may be for education, it may be for starting a new business, it can be for buying a new house, or it can be for wedding of children. So many requirements that come up for a period of time during our lifetime. That being the case, how do we ensure that these needs are met with the assets we create? So that is again the management of it. Next is estate planning is necessary for preventing financial and legal grief to the family. What does that mean? Post our lifetime, the family, of course, they are going through the grief of losing the person. At the same time, we should not put the family into distress by not giving them the right inputs on where the assets are located, how it can be accessed, how to liquidate those assets, or where are the paperwork located, or what are all the assets that are available for them to ensure their financial needs are met. So, hence, estate planning also emphasizes that the family is aware of the whereabouts of the assets that are created. That is another aspect. Next is optimally deploying funds to generate money out of money or out of wealth. That means to say how optimally the person can make use of the available assets to generate further or to grow the assets itself. It can be through investments, various investment means that one can achieve that. Apart from that, it is also very important that the person takes up life insurance and medical insurance as a cover because of the current scenarios, the situations that we have gone through, where medical expenses are skyrocketed. At the same time, the dependents in the family do not suffer because of loss of a earning member. That being the case, life insurance and medical insurance is also part of estate planning, which is key element, and we recommend every one of us to have these two insurance covers. So with this, knowing that estate planning is very important for anybody and everybody, and these are the importance or the benefits of estate planning. While these are the importance or the benefits that we have called out now, we will touch upon the management aspects alone and not the wealth side of it. The wealth side of it, we have wealth advisors and investment advisors who are experts in the subject matter, and then they can guide, where we recommend you to hire or engage such people to help you and support you in managing these assets. At the same time, there are insurance advisors who will help us in identifying the right type of insurance plans that needs to be taken up. While we have experts on those aspects, we will be touching upon the mechanism of managing the wealth through estate planning. So that is where we will talk about today about will and private trust. Most of us would have heard of will, and a few of us would have heard of private trusts. And the concept of private trust is growing nowadays. This concept is there in India since 1881, and however, it is not so prevalent in India until recent past. However, there are other countries, developed countries, where private trusts are managed or set up basically by most of the common man, um, and it is frequently done. So having said that, before we get on to or touch upon private trusts, let's briefly understand what are the things that we should know about will. So will basically a declaration or a document written by the testator. Testator is the person who writes or executes the will. Okay. So it is a mechanism of providing, it's a document which provides mechanism of distribution of assets post demise of the person. That means the will comes into effect only post demise and not while the person is alive. Having said that, the person can amend and update his will unlimited times, umpty number of times until he is alive. So, who executes a will? The person. The meaning of execute here is who brings the pointers that is put in the will into action. So the will also should identify a person as executor. That person would be identified generally by the person who is executing the will. who the testator, that is, who is making the will, and that executor will ensure that the the contents of the will is brought into action. So the executor can be a lawyer, a chartered accountant, a family member, or a friend, or a well-wisher. There is no restriction that executor should be only a legal person, not required. Then we come across registered will and unregistered will. Um, Basically, the will has, we recommend, and most of the legal experts also recommend that will has to be registered so that the complications are mitigated to a great extent. What are those complications if the will is not registered? Basically, the will can be contested. Both registered as well as unregistered will can be contested. Where the will is registered, it is not so easily contested by the other party or a third party because it is documented before the sub-registrar. That being the case, it becomes difficult for the third parties to contest or challenge the will or the contents of the will. While that is so, unregistered will can always be contested, and it becomes the work, or it becomes the beneficiaries mentioned in the will has to demonstrate that they are the legal heirs. The will that has been discussed is the valid document, and then the witnesses who signed at the time of executing the will should be present. All these activities should be, it goes as a process before the courts, and it's a long drawn process. The court will examine all these aspects, and then the court will make an order. So that being the case, unregistered will can always be challenged if there is an intent on the third party to create a problem. So that being the case, we always recommend that will has to be registered. Now, will also should be executed on in writing, preferably, uh, because oral wills are also talked about. But today's times, we always recommend it to be documented, that is written or typed out and then signed. All the pages must be signed so that there are no frauds that can creep in, and it has to be witnessed by two witnesses. Now, witnesses can always are always individuals. So in future, it becomes difficult for the person, for the beneficiary to bring the witnesses if they are not traceable or they are no more. Those situations we come across, and hence it is always recommended that registration of will is important. Few things that needs to be taken care or kept in mind is will through will personal assets can be documented as part of it. While that is so, inherited properties are dealt with separately because it is not just the person's will to devolve or pass through inherited assets, because inherited assets can be always challenged by the other legal heirs of the person. For example, if I inherit my father's or grandfather's asset, I can only deal with it with the approval of other legal heirs. That is through a release deed. And similarly, there can be HUF assets. HUF assets, though I'm Karta of my HUF, I can only deal with it only post partition and allocation of those assets amongst the members, not before that. That means I cannot will my HUF assets to the people whom I wish to as it is. So having said this, with the overview of will, let us sum up the challenges that we came across just now. One is for the will to become effective post demise of the person, it may be challenging because there can be third parties who can challenge it, and it can be time consuming because of the court process, which we call as probate. Now, apart from that, legal hair certificate or family tree, etc., are the documents that may be required in the court process. And this becomes again time consuming. Next, accessing will is always kept personal. So many times we hear that the family members were not aware of the will written by the person. While that is so, it may so happen that the family members may not really get the access of the will in time. That means to say they may not get the access of the assets or money in time. So that means there may be delay, or the delay may be because of the time consumption which is required for giving effect to the will. That being the case, the other aspect is where the person wants to bequeath portion of their assets or any of their assets to non-legal heirs. It can be, for example, friends, children, or some NGOs or not-for-profit organizations. There again, the legal heirs may challenge such bequeathing of assets. So it makes the process difficult. The process of giving effect to the will difficult. That being the case, will has its own challenges, and hence we will be discussing going forward the alternate mechanism, which is a better or a preferred mechanism over will. In the meantime, we will have a short poll. We request the attendees, the members here, to go through the poll and then exercise your choices. This will help us in having more insights and then serving better. So the poll is being a very simple poll, a one question poll. I think most of us have answered it. So let's move on to the next aspect, that is about private trust. I'll hand it over to my colleague Mythili. She'll take us through the further slides. Over to you, Mythili.
Thank you so much, Arun. Good evening, one and all, and welcome to our session. Thank you so much for taking us through the requirement of a will. Will, I would suggest, has always been a bare minimum document that any individual has to have in or if you have a considerable amount of wealth, so that there is more clarity. But of course, will has its own set of issues which has to be addressed. So if there is a lot of wealth involved and you need more clarity during your lifetime and you want to ensure the assets move on to your next generation in a structured way, private trust is considered as one of the alternative. So to take you through what are the use cases of a private trust that we have seen as part of our consulting and advisory assignments. Now, private trust is where you have a case of multiple businesses and you want to structure your succession planning. That is one of the places where private trust is extensively used, where you want to protect your personal assets and you have a lot of exposure to liability on your professional front. So that is one of the areas where people have explored the concept of a private trust, where you want to ensure that there is more clarity with regard to your bequeathing and inheritance and prevent any possible dispute. Private trust is used because private trust is implemented during the lifetime of the person rather than as against a will, which comes into being after the death of a particular person. Private trust is also one of the place which is explored where people have differently able children and they want to ensure there is a mechanism of our children being taken care beyond their lifetime. So also in the case of minors where there is any eventuality where the assets have to be taken care on behalf of the minor till they take control over it, private trust is an excellent route in order to manage your inheritance, and it will give you more clarity and the mechanism as to how the inheritance flows and what is the intent of the person who transfers these assets, what does he want to do, that there'll be a lot of clarity in the document, and that paves the way for a trustee to take it forward. Now, why is private trust considered? As I said, um, a trust is something that is implemented during the lifetime of a person, and it ensures a perpetual existence. So even after your death, there is a reason, where there is a mechanism which says with a lot of structure as to how the future is being planned for the family. It protects against, it helps to ring fence the family's wealth. All the assets are pooled into a single unit. So there is a lot of ease of administration because all the assets are not in multiple names. Everything moves into a single trust where the assets are pooled. So there is more structured manner on and ease of administration. Now, in a lot of countries, we also have come across this private trust as a mechanism for inheritance tax issues. We don't have currently inheritance tax issues in India. We might face in future, but how the legislation will pan out, we'll have to wait and watch. But in since the structure can be predominantly from a regulation side, whatever has been done in other countries, we would assume that there might be something similar which will be enacted in India. This could be a plausible solution for a future inheritance tax issue, but we'll have to wait and watch as to how this plays out. So having said that, let's move on to see what is the benefit of a private trust structure. You will not first have a problem of disputing because once a trust is put in place and a trust deed is created, every member who are going to be the future beneficiaries also get to know how the trust is going to take place. So there is more clarity and um, people get to know during the lifetime of the person who's intending to bequeath also what is the way forward. Then there will be minimal regulatory compliance with regard to managing the different types of challenges that comes as part of will, with regard to having a legal hair certificate or ensuring there is a smooth transition of your funds from your account to another person's account. Because everything, even though the person is died, the accounts and everything and the bank account is always operational, and the trust is a separate entity. It's easy managing funds. It helps providing a lot of clarity, gives to harmony. So it gives a lot of harmony from the family side because everybody is kept in knowledge of what is going to be the way forward. You don't have the problem of proving a private trust as compared to a will. So if it is an unregistered will, as Arun said, we might have to go through a probate process. That is that is avoided in the case of private trust because the trustee talks by itself and is stronger than a will and can be executed separately. So we will take this forward. So I'll give you an overview as to how the trust process happens. So you identify all the all the assets that you want to pull together, and you want to ensure that it is structured in a certain way. You take the assets and you pull it into a single unit, and the unit that you create is called a trust. Now, once the assets move into a trust, you can ensure that your assets are protected because it is gone from your name onto another name, which is the trust. And the trust, the assets are held for the benefit of your future generation. This is how a typical family trust would look like. One, it would have a settler. A settler is a person who creates the trust. So he moves his assets, that is his wealth, into a trust and contributes to a trust and in the custody of a trustee. The trustee is the person who manages the wealth which has been given by the settler. He is not the owner of the assets. His role is that of a custodian. The trustee manages the assets which are held in the trust for the benefit of the beneficiaries. Now, beneficiaries are people who will not have access to the assets in the trust, but they will be the ultimate beneficiary in the sense that they will be the people who will enjoy the asset or any income the asset actually produces. So they are the people who will be the who will receive the benefits from the trust. The trustee does it more out of a role as a guardian or a protector of the assets of the trust. So once the settler actually transfers the assets into the trust is created. So he will have to settle it in turn. The whole thing is done through a document which is called as a trust deed. You will have three main callouts in a trust deed. One is your settler, and second is your trustee. You can appoint a trustee, and then you will have a beneficiary. So what does typically a family trust look like is that we have seen in majority of cases, the trustee also will be the settler. The settler intends to manage his asset through a new vehicle. So most of the cases we have seen and we have done is through having the settler as an initial trustee. So he provides the guidance and he takes control of the asset. From he managing it by himself, he has moved the asset into a trust and now he is managing all his own assets in the trust, in the capacity as a trustee. Then, post his lifetime, he can lay out as to who will be the next trustee, or after the life of the spouse of the trustee, who will take over and provide a direction as to who will be managing the trust. The trustee is a very important role, and they do not enjoy the assets in the trust. Now, in some of the in some of the trusts that we have observed, we have also have a person called as an observer. This is an optional point that we have. An observer moves in the role of that of a consultant. He generally doesn't work as a trustee. He doesn't have anything. He is like a wise counsel who provides guidance to the trustees in case they have any issue. The observer is generally a person with a lot of financial prudence. It could be a chartered accountant or it could be any of your lawyers. We have seen multiple people or even some of the people who have been close to the family and who have the best interest of the family and the beneficiaries in mind also can move into an observership role. But this is not mandatory to have it in a trustee. But these observers work as consultants and they provide direction in case the trustees are stuck somewhere or they need a guidance. So apart from that, we can also have a concept of what is called as an executor. You might ask me why, if you have a trustee, why do you need an executor? Generally, the important aspect for a trust is to have a trustee at all times. If there is no trustee, then the trust fails. So there should always be a perpetual existence for the trustee role, not for the person, but for the role. There will always have to be a trustee, otherwise the trust can be wound up. So having said that, if there is any scenario where a trustee is not there for a trust and it has to be wound up, you can have some person who is closer to the family or anybody whom you have confidence in who can step into the role as an executor only for the purpose of winding up the trust for a brief period, getting into the role of a trustee, ensure the assets are distributed to the beneficiary, and once the job is done and the assets are distributed to the beneficiary, the executor's role closes. But the executor can be named beforehand in the trust document itself, and he will not. For all these cases, whether a person is appointed as a trustee or observer and executor, you need to inform them and make them aware of the fact that there is a trustee and this is what you intend to do. Have a conversation with them, get their acceptance to the role, and then name them. Naming them will provide a lot more clarity in case the beneficiary needs help or they need to be taken care or any of the trustees are stuck somewhere. The trust document will have a lot of clarity as to who is to be the next in line. So a trust document can be customized to the needs of each person and each family's requirement. It is not a one-shop document where you can just download and change the names. In each cases, the whole process of preparing the document itself goes into several months because you need to understand what are your requirements, how the deed needs to be structured, what is the thought process. A lot of thought process goes into defining these roles and assigning people to these roles. And a lot of conversation has to happen in the background to enable this. Now, When we talk about trust, there are very common aspects of that is we come across is what are trust in revocable trust and irrevocable trust. Now, revocable trust are basically a type of trust where you as a settler can transfer the assets to the trust. At any point of time, you can take back the assets that you have contributed to the trust. So this can be during the lifetime. So the legal right in the particular asset stays with you and it doesn't move to the trust. You have parked it into a trust for a period, but you can at any point of time take it back. In most of the cases, we come across this concept of irrevocable trust in case of public charitable trust. There, most of the trust deeds are generally structured as an irrevocable trust. So the revocable trust is the beauty of a family trust. You can structure it in the form of a revocable trust and state that post the lifetime, the trust would become irrevocable. The other thing is an irrevocable trust. Irrevocable trust is an opposite of a revocable trust. You give the assets, and once you have transferred the asset, you don't have the right to your assets. The assets move into the trust. It becomes the assets belonging to the trust held for the beneficiaries in the trust. You don't have the right to call back on the asset. Now, the implication for a revocable or an irrevocable trust, usually we see it from the impact of it, apart from the legal aspect, which I have told, comes up also in income tax. Because in case of a revocable trust, typically what happens is the income from such asset is clubbed back to the settler's name. Whereas in the irrevocable trust, it is assessed in the hands of the trust itself, which would be sometimes at the maximum marginal rate. It need not be, sometimes it would also be depending on the beneficiary. So I'll move on to another type of trust, which we come across when you do a trust deed, which is called as determinate and indeterminate trust. So a determinate trust is typically from a beneficiary point of view, where you have determined the interest of each beneficiary in the particular trust. Now, an indeterminate trust is an opposite of a determinate trust, where you don't know how much each beneficiary is entitled to in the trust. So, an indeterminate trust is a case where you just have the assets pooled into a trust, and then you give a discretionary power to the trustee, saying that you decide at any point of time how the assets or any income has to be distributed. So, the trustee has the power to determine at any point of time, or if there is a guidance provided by the settler, he can adopt it and say that this is how the benefit will be in future, and he can define it, but it is not required for him to drop it in the trustee. So in a determinate trust, you specifically provide saying that as long as I am there and my spouse is there, we would be entitled to 50-50%. After me, my spouse will have so much percentage. My son or daughter who will be beneficiary of the trust will have such and such a percentage. So in these cases, you might have a different aspects to it, where you will have to state what is the each beneficial interest of each of the beneficiary in the trust. So tax angle to the whole impact is that in case of a determinate trust, the share of each beneficiary is actually determined and then it is clubbed in the hands of the beneficiary. In case of an indeterminate trust, because there is no mechanism provided in the trust, what is the share of each person? This goes into a maximum marginal rate, which is the highest slab that is there. And the trust has to pay taxes. Here, you determine the income, park it to the different beneficiaries, and each of the beneficiary will pay tax out of the money that has been allocated to them. Now, coming to the aspect of once you have concept of you have created a family trust. So what is it that you actually move into it? So you can move an immovable property. If you have to move an immovable property, I'll just briefly analyze the impact if you do it through a trust or through a will. If you do it through a trust, what you're effectively doing is transferring the property that is in your name and you're transferring it to the name of a trust. So this would be deemed as a transfer and you would have stamp duty implication. Whereas if the same has to devolve on anybody through an inheritance route, then there will be very minimal stamp duty there. So generally, in case of will, you have very minimal. It will be only transfer charges, and whereas in through the trust route, you will have significant impact. So this is the cost you need to analyze. So private trust is not the only route. Sometimes you can do a combination of both private trust as well as a will. You can do it in combination in order to achieve your estate planning requirements. Now, other things that can move are investments or any amount of money that you want to settle into the trust. In case you do it through and transfer through a will, what happens is that a will can always be open to it can be contested, because there might be sometimes the person who's writing the will may not actually keep the people who are beneficiaries or the family aware of what they want to do. So there can be future feuds that can come up. Whereas in case of a trust route, there is ease of managing the money, as well as everybody has clarity as to how the assets are moving. So it is investments and money is something that can be easily managed through a private trust. Even in case of business interests, trust route can be avoided, can be used. Just like how I said, it is an effective tool for succession planning, where you can have a person if you have different children, you have different businesses which are there, and you want each of the business to be bequeathed to a particular child. This can be done through a private trust route. So this is something that is unique. We can have a beneficiary. How do you manage the beneficiary? The beauty of a private trust is that it can manage itself beyond the life of the person who is settling it. So even if the settler has passed away, the private trust works by itself. There you can actually impose what we call as a waterfall mechanism. What do you mean by a waterfall mechanism? During the life of the settler, you can choose that the settler and the spouse of the settler can be the initial beneficiaries to the trust. Then going forward, the settlers can also identify who will be the future beneficiaries. So you can have different staged beneficiaries. So the initial, secondary, tertiary, and going forward. So once the trust deed is there in place, whatever has been the intent of the settler will have to be put into action by the trustee. So the trustee is bound by the trustee. So once the trust provides a direction as to who will be the future beneficiaries, the trustee's work is to make sure that the intent of the settler is put into action. So it can be initially the person and the spouse, then it can be the children post their lifetime, and then after them it can be their grandchildren, and it can even last their children, and the trust can continue despite the lifetime of anybody who is part of the trust. Now, just like how the beneficiary can be managed as part of a waterfall mechanism, the trusteeship also can be managed through a waterfall mechanism. So apart from identifying, the settler can identify he being the initial trustee, he can manage it himself during his lifetime. And post the lifetime of the settler, they can identify the next person who can be the trustee, or anybody else in the family, or it can be the spouse of the trustee, or it can be the son or daughter of the trustee. It can be taken forward in such mechanism. So this whole thing can be structured in such a way that it lasts beyond the lifetime of the settler. Some of the trusts that are structured or also provide a mechanism for future marital discords, where they exclude the spouse of the children or the grandchildren from enjoying the benefits from the trust. You can provide it in the trust, which you cannot do it under a will, because inheritance and succession will take over. You will have very little control over who can be the future beneficiaries if it is in the case of a will. Whereas in a trust structure, you can actually provide in such a manner that only the children and grandchildren are only the beneficiaries of the trust funds, and you can exclude the spouses of the children or grandchildren from this. So this is the flexibility, and this can be customized to your requirement. This is based on each person's what they want. So it is completely customizable to the intent of the settler. So next is with regard to the scenarios. Arun, I'll hand it over to you to take forward.
Thanks, Mythili. So, friends, until now we heard Mythili taking us through the the characteristics of trust, the components of the trust, the different types of trusts that we can know, understand, and set it up. That briefly she touched upon the tax impact also. That being the case, and also she touched upon how the assets can be transferred or put into the trust, or we call it as settle into the trust. Just few things that I would want to add upon here is one is the assets need not be settled into the trust at the beginning of formation of or creation of the trust. It can happen in staged manner. That is one aspect which I wanted to add upon. The other aspect is um, the will. The person can write a will wherein he can cover the immovable properties, because Mythili did mention that it can be combination of trust and a will. The will can be only with respect to the immovable properties, and that will always can say that upon it becoming effective, that is upon demise of the person, the assets, that is immovable properties, can go to the trust. Even in that situation, the stamp duty upon on transfer of immovable properties through a will to the trust is minimal. So this is another aspect which wanted to add upon. Now, once we understand how and how it is done, why it is done, we felt it is important to understand few scenarios or few structures that we can think of while creating a trust. So the first scenario that we are talking about here is Mr. A is settler, and Mr. A is also a trustee, and Mr. A is the sole beneficiary. So the question comes up here is this structure feasible? So what has happened if I go back to the slide, what is happening is Mr. A is occupying all the positions as a settler, as a trustee, and as a beneficiary. This defeats the purpose of the trust. The reason is he is transferring his assets to the trust where he is alone the beneficiary of the trust. Then what is the reason of creating a trust? He is just creating a layer with no purpose in it. Hence, the trust fails here. That being the case, what is the ideal structure? Let's look at the ideal structure, how it looks. So, Mr. A, in this example, Mr. A is the settler, and he is also a trustee. However, he is settling his assets for the benefit of himself and his wife as primary beneficiaries, and children or any other specific beneficiary as secondary beneficiary. That means apart from Mr. A, there are other members who are beneficiaries, who are identified as beneficiaries in the trust deed. This is where the trust prevails, or trust creation is with a purpose. So having this basic understanding that it needs a settler, it requires a trustee, and there must be a beneficiaries apart from the settler as part of the trust. Let's look at few other situations and understand, are there any complications or are there any situations that we can think of. So here again, Mr. A is the settler. He holds certain personal assets, and also he holds shares in X Limited. Now he will create uh, a trust where he is also a trustee, and the beneficiaries he is covered in the trust deed are himself, spouse, and children. So by doing this, what is that he is achieving? his intent was to, protect his private assets, family assets from professional and business liabilities that he may foresee in future. That means because he is in, maybe looks like he is in a risky business, or he is getting into something very riskier, and which may result in huge liabilities if it is not managed well, and hence he wants to protect his personal assets where his family interests are vested also. That being the case, he would want to transfer the shares in X Limited and personal assets into the trust. With this, what he is achieving is he's trying to protect the family interest in the family assets, which we call it as ring fencing. However, since he is also a beneficiary, to the extent of his share or his interest in the trust, he's still exposing himself towards his liabilities that may come in the future, or which he may be foreseeing. So that being the case, his portion alone is exposed towards those liabilities, but not with respect to the other members' interests. So let's look at a few other scenarios. The other scenario is where the trust is structured, or trust is set up to cover the succession planning. So in this case, let's understand the case. Mr. A is the settler. He holds a couple of businesses and he has two children. Okay. Though son A and son B is written, I'm using the word children. Okay. So he has two children, and each of the child is interested in each of the business and not in both the businesses. Assume that is a scenario. Then what happens? Then it is easy for Mr. A to transfer the ownership of these businesses into respective trusts. So we may recommend setting up two trusts here, where one trust talks about holding business A or entity A, and the trust two holds interest or ownership of business B. That being the case, in each of these trust deeds, Mr. A can clearly call out that who has the ownership, who enjoys the benefits of these businesses, as well as who has the control and management of these businesses. Because through a trust structure, the control and the ownership, or management and ownership, can be bifurcated or can be separated and allocated to different people. That being the case in Trust A, where business A is held, and Mr. A can say that because son or child one is interested, child one can get to manage, and in the same fashion in Trust 2, where business 2 is held, child 2 can manage, while the benefits or the profits that comes out of these two businesses can be shared amongst both the children's family, or it can be earmarked to those specific child family alone. That is possible. Here again, we can always bring in the waterfall mechanism that Mythili discussed some time back. So this is where the succession of businesses helps. Same fashion, succession of assets, whether it is immovable or movable or financial assets, can also be structured. And should this be done in two trusts separately? Answer is no, not necessarily. Based on the situation, based on the needs, it can be structured in through multiple trusts, or it can be structured in one single trust itself. So there are a lot of permutation combinations and structures possible. Because of this very nature of trust being flexible, it is also recommended that it is a well thought or thought through process and should not be done in a hurry. Let's look at one more scenario. Here we call it as conditional succession. What is that? Let's understand. So settler wants to holds a business. Settler is running a business activity, business entity, which he would want the ownership he would want to transfer into the trust, wherein the beneficiaries are himself and his child, or and as well as spouse. That being the case, he would also want to bring in a condition that the child gets to manage the business only if the child completes certain professional course. So this is the settler is trying to bring in a condition onto the child, saying that the control and management, not the ownership, just the control and management would be given to the child only if the child is capable enough. And for that, the benchmark that he is setting is that the child has to go through a professional course. I mean, it may be a right or wrong, which we are not contesting here. However, these kind of conditional successions are also possible. So, what happens if the child goes through and completes a professional course? Then the child gets the control and management of the business, again through the trust itself. If the child is not able to complete the professional course, then what happens? Then the condition that the settler puts in here is a professional executive has to be hired as a CEO of the business, and then it has to be professionally run. It has to be run by the professionals, and then the child will get to enjoy the benefits or the profits of the business alone, which is fair enough. So that means to say the settler doesn't want to, hamper the growth of the business or trouble the business due to incapability of the child. That is his vision that he's trying to bring through in this situation. Okay, so let's look at another scenario. Of course, while we are going through these scenarios, I'm sure most of us will have various questions, queries. We will try to address it. Please post your questions in the Q&A tab, which is available to every one of us. And we will try to address these queries, these questions towards the end of the session. So coming back to other scenarios. So Mythili was explaining some time back that special needs child, special care child also, interest also can be protected through a trust. So let's understand how this works. So Mr. A has, has settled his assets into the trust, and the trust is run by trustees. To start with, Mr. A and Mrs. A are the trustees. They also appoint a corporate trustee to run the show in case of unforeseen situations. And the beneficiaries are Mr. A, Mrs. A, and children. One among the children is a special needs child who needs a special care, who needs care throughout the life, and hence this trust has been structured. So what happens? Post lifetime of the trustees or the settlers, the close family members or a friend or a well-wisher can oversee or can become the trustee also along with the corporate trustee, or they can be appointed as observers just to ensure that everything is going through as per the requirement. And sorry, also the settler should have identified the caretaker agency as the agency to take care of the special need child post lifetime of Mr. A or Mrs. A, or disability. Once Mr. A and Mrs. A are not capable of taking care of that child, the caretaker agency has to become active and then start taking care of such special needs child. That is the intent that settler should have brought into the trust, and such agency also should be intimated about this kind of situation. And the trustee also, where we talked about corporate trustee, uh, should also be aware of this purpose of the trust that is being created for, and that is how the trust can be run effectively. Now, why is that we brought in corporate trustee in the structure is mainly to ensure the continuity of the trust. What do we mean by continuity of the trust? The trust fails or the trust structure fails if there are no trustees to manage the trust. That means it heads towards dissolution. So in this situation where special need child, just going back to the point, what happens when the trust dissolves or comes to an end? The assets would get distributed to the beneficiaries as per their beneficial interests or the beneficial interest that they hold in the trust. That means in this situation where special needs child is there who cannot manage uh, on own and a caretaker agency is required, the trust structure has to continue. So uh, we can ensure that trust continues to perpetuity only if there is a corporate trustee appointed and not an individual. Even in case of individuals only being appointed as trustees, the trustees board or the trustees together should always have a backup plan that who will be the next set of trustees can take over the position of trustees in case of any unforeseen situations. So this backup plan is a must. Otherwise, the trust fails. Hence, corporate trustee concept has been brought in, and we do have corporate trustees in India also who act as trustees. These are called trusteeship companies. So this is the structure in this situation where special needs child um, is a matter of concern for the parents. So the let's look at another scenario where cross-border holdings are visible. I mean to say, today's times, most of us would have traveled outside India, worked there for a while or run businesses for a while. We would have created assets outside India, and hence the assets are located in different jurisdictions, different countries. That being the case, or alternatively, people would have created assets in India, but they would have moved out of India and they would have become non-residents. In these different scenarios where the assets are held in cross jurisdictions or overseas, or the people are resident overseas, what happens or what should be done to transfer or how the trust structure can be effectively implemented? The 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 point here is, since there is cross-border holdings or cross-border assets being situated or assets being situated in overseas, apart from Trust Regulation Act, that is Trust Act or trust regulations being involved, all and income tax being involved, there is this FEMA regulation, that is Foreign Exchange Management Act, also comes into play. Here, it is very important for the settler to know that under FEMA, there is a thumb rule or a general rule, unwritten rule that we all understand. It is what cannot be done directly, cannot be done indirectly. That means if something cannot be done directly, it cannot be done through a trust structure also. So with this basic understanding of FEMA regulations, we should also see whether we are overstepping the FEMA regulations while creating the trust. For example, if a person is resident in India, wants to create beneficial interest in favor of his children who are situated outside India, if that is not possible to be done directly, the same rule applies even through a trust structure where such creation of beneficial interest would not be possible through a trust. Hence, there are related regulations, that is overseas direct investments, LRS, and foreign direct investment regulations that apply here. Hence, if you are creating a trust in favor of non-residents, or non-residents are creating trust in favor of residents, it is always important to be aware of FEMA regulations and then create the beneficial interest. Otherwise, it will be contravening the provisions, and hence it becomes void. Of course, we will not be getting into the nitty-gritties of FEMA regulation here. That is a subject in itself, a vast subject, and hence we just wanted to give snippets here how the structure looks for FEMA purposes. Yeah, having gone through these 6 or 7 trust structures, of course, there are multiple more structures that we can discuss, but for paucity of time, we picked few of the situations here. Moving ahead, what are the key aspects? That means now that we went through the formation, the creation, and the type of trusts, and we went through the scenarios, different scenarios of the trust. So we felt it's wise to sum up the key aspects of the trust as a reminder slide, so that we all carry this in our memory, and then it can come back whenever that is needed. So the key aspect number 1 is very much necessary. The settler who wants to create the trust has to understand what is the purpose of the purpose with which he wants to create, or what is the intent with which he wants to create. Without the purpose, without the intention, it becomes another vehicle, another entity that gets created, and it doesn't serve any purpose. Hence, we recommend to identify the purpose and the intent for creating a trust. That is key aspect 1. Number 2 is identify the beneficiaries. Here again, it is very important. Beneficiaries are supposed to be identified. Even if the beneficial interest sharing ratio is not identified, it's okay. It can be indeterminate trust. However, beneficiaries are required to be identified within the trust to avoid any kind of ambiguity. The reason is the trust is created is to remove any kind of ambiguity, any kind of confusions, and hence we should not create the trust and add more confusion to the situation. The next is identifying all the assets that should go into the trust. It means also to say that identify those assets which the person should not or do not wish to move into the trust, which can be held privately, which can be held in personal name, which can be dealt with separately by him in whatever means he or she wish to do. Next is decide the type of the trust based on the revocability as well as determine whether it is indeterminate or determinate. Based on that, it has to be decided. And this decision differs from case to case, and hence the situation has to be analyzed before this decision is arrived at. Next is identify the trustees. Who will be the trustees during the lifetime of the settlers, and who will be future trustees post lifetime of the settlers. And there can be a call out between family trustees and external trustees or outside family trustees. That flexibility is also can be brought in. Next is name of the trust has to be kept. I mean, trust has to be named for it is necessary for the purpose of creating a trust. And the last but not the least, the trust deeds needs to be drafted. It has to be executed. That is, it has to be signed by the settler. There can be joint settlers or single settler, and trustees also should be available for the purpose of registering the trust deed. before sub-registrar. So these are the key aspects. Of course, there are a few other aspects that we can add here, but for now, let us assume these are the key aspects that are necessary and for the purpose of creating a trust. Yes, now that we are towards the end of the session, we have around 22 minutes more. We wish to take up questions. I think I'll ask Vijay Sima or somebody to give unmute rights to all of the attendees. Before that, yes, we have another poll that my colleague has launched. Request you all to, it's again a one question. Please go through this and then provide your answers. This again helps us in analyzing and having more insights into it. Okay, thank you for the answering the polls. We have received quite a few answers. We wish to have others also to answer the poll. In the meantime, let's open the floor for Q&A. I see some of the hands being raised. Let me unmute. Yeah, Mr. Lakshmi Narayan, I have unmuted you.
Yeah. So this is Lakshmi Narayan from Chennai.
Yes, sir.
In case settler transfers his asset to the trust, is there any capital gains tax that he has to pay?
That's a very good question, sir. The tax law, if we read section 47 and along with that section 56, what the law says is if the trust beneficiaries are relative to the settler, then such transfer is not construed as a transfer. It is not regarded as a transfer under section 47, as well as for the beneficiaries, it is not a income under section 56, and hence, so they should fall under the relative definition. Then alone, this section benefit can be taken. Otherwise, it amounts to transfer.
Okay. Can I ask one more question?
Yes, sir.
Say, when the trust is formed, if all the beneficiaries dies, what happens to the trust?
If there are no more beneficiaries, sir, then again trust comes to a end and it gets dissolved. So there should be necessary clauses built into the trust as to what happens when there are no more beneficiaries. Generally, either the legal heirs as per Hindu Succession Act or any other succession act that prevails may come into picture.
Okay.
Yes, sir.
Okay. Thank you very much.
Thank you, sir. Thank you. Yeah, I think
next, Aparna has raised her hand.
Yeah, Aparna.
You can unmute yourself.
Yeah, you can hear me, right?
Yes, yes.
So my question was, let's say this is actually very personal because my children right now are residents, but they're living abroad. And what happens if they become non-residents later? How will do you go back and change the rules in the trust, or should we before starting the trust itself we must write all those rules?
So my view at present would be the trust clauses or the terms and conditions that we bring into the trust may not change just because of change in residential status. That I think generally it remains as it is because the beneficiaries become non-residents in future and not when the trust is being formed. So our view is at present prima facie we are of the view that the change in residential status will not impact the beneficiary's beneficial interest in the trust.
Okay, so the tax implication, we'll have to look at it later. That's what you are saying, is it?
Tax would not differ.
Yeah, okay. So when you discuss that overseas slide, you were telling us, to keep all these things in mind. And
correct.
So,
yeah. When we discussed on the cross-border holdings, we mainly discussed from foreign exchange regulations perspective and not, let me go to that slide. Yeah, sorry. Yeah, cross-border holdings. So when we discussed here, the emphasis was more on foreign exchange management regulations, which talks about cross-border creation of cross-border beneficial interest and not from tax perspective. Tax regulations remain the same, whether we create a trust or not create a trust, whether the person is resident or a non-resident. Of course, there are few regulations like tax withholdings comes into picture. Those are minimal. Otherwise, a broader level, the tax regulations remain the same. But this is important when we are creating interest or we are creating beneficial interest in favor of non-residents.
Okay.
Yeah, not subsequently they become non-resident.
Okay. Okay. I have one more question. Can we determine the date when the trust will get disillusioned? Can we say? Yeah.
Go ahead. Sorry. Go ahead.
Yeah, that's all. Can we determine it? Can we say that when you start the trust itself, can I say that, 30 years down the line, I want the whole trust to be dissolved and beneficiaries to get the money or something like that?
Absolutely. That is possible. And we call it as time-based or it is open-ended. So the trust can be time-based, post which time, as you rightly said, after 30 years, you can say that the trust gets dissolved and the beneficiaries get the share in the assets of the trust. That is possible.
Okay. Thank you, sir.
Thank you,
ma'am. Mr. Amar has raised his hand. Oh, you can unmute yourself. Yeah.
Yeah. See, my question is, we have seen where some of our clients, they have created trust. They are basically a person of Indian origin who has settled abroad and created a trust there, which is quite common in US. The family trust will be created as a succession planning. However, for whatever reason, he may repatriate to India and then settle down in India for good. So he becomes a resident in India. So settler is a resident who is the creator of that trust. However, the beneficiaries or the assets are located outside India. So when those trusts assets are sold abroad, whether that will be taxable in India because the settler is a resident of India.
Yeah, very interesting question, Mr. Amar. So, first of all, similar to the revocable and irrevocable trust, we do have something called grantor trust or otherwise in US, where it talks about revocability. That means once the person has revoked, let's say it is irrevocable, then once the settler settles his assets and into the trust, his job is done. That means he cannot recall. So his residential status really doesn't matter. Alternatively, if it is a revocable trust, then whenever he wishes to, he can always recall the assets from the trust. So please look into this aspect first. Number two, assuming it is irrevocable and trust assets are liquidated and there are capital gains to be paid, first of all, US will have first right to tax the capital gains. And next, if the beneficiaries are residents in India, again, because of their beneficial interest, it has to be reported in India because of the very nature of trust, which acts as pass through, and hence they have to report it in India also. But please look into the foreign tax credit aspect also.
Okay. So you, just to sum up, you mean to say that if it is a revocable trust, then we may have to look into the aspects. But if it is an irrevocable trust, even if the settler is an Indian resident and the assets are disposed of outside India, then there may not be any tax implications.
Correct.
Oh, okay. Thanks, Arun. Thank you.
Mr. Rajiv has raised his hand. Sir, you can unmute yourself.
Mr. Rajiv. Okay, we'll go to the other person.
Delhi. My
Mr. Rajiv, your voice is breaking. Can we take up the next question? By then,
Mr. Gangadhar has raised his hand. You can unmute yourself. I've given you the access.
hello.
Yeah, Rajiv. Yeah.
Yeah, am I audible, sir?
Yes.
yes, yes, Mr. Rajiv.
Yeah. Thank you. So my first question deals with taxation under section 47 and 56. They basically deal with the capital gain under Income Tax Act. So my question relates to the transfer of property tax, which say varies from 5% to 7% and things like that. So let us say I'm a single owner of one property and joint owner. Hello. Hello.
Yeah, Mr. Rajiv, go ahead. You're audible.
Thank you, sir. So the first question in where I'm the let's say single owner of this property, do I have to pay some transfer of property tax to that local government authorities? And in case there is a joint property, do I have to be taking permission or some kind of clearance from my joint owners? This was my first question, with your permission. Thank you.
Okay. So to answer your first question on stamp duty on transfer of property, we all know that stamp duty is a state subject, and for example, in Karnataka, transfer of immovable property from individual to trust, it suffers stamp duty. Similarly, you will have to look at what the Stamp Duty Act talks about in Delhi.
Great.
That is
Great.
one. Coming back to your second question, where should you take permission from your joint owner? See, joint properties are generally are having undivided share concept, means it is not demarcated, and hence legally I'm not equipped to answer this, but logically I would say it's always preferable to inform your joint owner before you do anything of this sort, because while you do the transfer, he may also be required for certain compliance activities before sub-registrar.
Okay. Thank you. And do I have permission to take up my second question?
Yes, please go ahead.
Thank you. This deals with the question of another participant where you had mentioned that open-ended trust and close-ended trust. So can the open-ended trust be converted into the close-ended trust in future? That's the part A of the question. And in case it gets converted into a close-ended affair, or it needs to be extinguished by the beneficiaries at some stage in future, how and when can they opt for it? Thank you.
Yeah. So the first part of the question is where you mentioned, can open-ended be converted into closed-ended? Yes, it is possible. However, all the beneficiaries should agree for it. Then alone, the open-ended trust can be closed-ended or specific time-driven trust. That is one aspect. The second question that you mentioned is, can all the beneficiaries come together and call for a dissolution of the trust? Yes, it is possible, provided the trust deed allows the beneficiaries to take such a decision.
Okay, so in the first part of the second question, you said in case all the beneficiaries agree or consent to conversion of an open-ended trust into a closed-ended trust, so then only it can so happen. But
Yes.
can the creator of the trust can he opt for this particular thing? Say today I am creating a trust. I created open-ended trust. let's say 5-10 years down the lane, I only, that is creator of the trust, intend to convert it into an close-ended one. So I cannot do it. Only the beneficiaries have the right to do so. Am I right?
Exactly, you're right. The reason is once, so this again goes back to the question whether it is revocable or irrevocable. If it is revocable, what easily you can do is you can always revoke the trust and create a new trust. That is possible. Alternatively, if it is a irrevocable trust, where the settler's job is done once he creates and settles assets, the settler does not have any right to amend the trust deed. Hence, the beneficiaries have to give consent for amendment.
But obviously, the revocable will be having, you can say, greater tax implications, because all the income of the trust will be clubbed into the hands of the creator of the trustee.
Yes, you're
Creator
right.
of the trust. So,
You're
like Ms. Mythili said, that income of that such kind of revocable trust will automatically get clubbed into the hands of the creator of the trust, and that will be kind of an tax inefficient methodology to opt for.
You're right. You're right. But that is how the trust, performs or prevails. But let me tell you, the trust structure should not be looked at as a tax saving mechanism, because we cannot achieve any. The purpose of the trust should be for non-tax reasons, not for tax saving mechanism at all.
Much appreciated.
Thank you.
Next, Mr. Gangadhar,
Thank you.
you can unmute yourself. Okay. Can we move on to the next person?
Yes, let's move on.
Mr. Ganesh has raised his hand. You can unmute yourself, sir. No, I guess.
Okay.
So these were the people who had raised their hand.
Yeah, I think Mr. Lakshmi Narayan has some questions.
Quickly, Sima, can you actually unmute them? Is it possible? Because Mr. Gangadhar mentioned the same thing. He's unable to unmute himself.
I have given the mic access to everyone, so anyone can just unmute and.
And now I can. Now I can. Can you hear
Yeah.
me?
Oh,
yes.
Great. Go ahead, Mr. Ganesh.
Appreciate. Thank you so much. I just wanted to know if one were to, so what is the typical operating cost year on year if someone were to set up a trust? And secondly, what is the one-time setup cost in terms of range one would incur if they were to plan to set up a trust?
Okay. Sir, it is very difficult to put a number to it, because it is always dependent on the kind of complexities the trust that we have to go through while creating the trust as well as operating the trust. But I can give list of items that needs to be taken care, and then you can put a cost to it. One, you need an advisor to advise you while you are going through the trust creation process. So that is very important. You need a financial advisor or chartered accountant or a lawyer to advise you on creating the trust. Next is drafting of the trust. After that, you have to register the trust deed, then open the bank accounts, then help you move all your movable and immovable assets, or if it is only movable and financial assets, help you move it. It can be stocks, shares, mutual funds, fixed deposits, or any other asset category. That is upon creation and transfer of assets into the, or settling the assets into the trust. Next is year on year, the accounts has to be maintained, the tax computations and the accounting financial statements has to be drawn up, and tax returns has to be filed. This is the annual activity that any trust should go through.
Hello.
Appreciated. So essentially, if someone were to maintain on their own individual books, if they were to split into two books, one is a
Correct.
trust book and other is individual books, now it's actually double the effort. But yes, for a larger game plan, that's how you can do it, Kailash.
You're right, sir. Absolutely.
May I ask the question?
Thank you.
Yes, yes. Please go ahead.
Yeah, just want I have a very small question and very simple question since I don't understand this trust aspect in detail. So what is the object of creating a trust and what are the benefits and what are the disadvantages to have a family trust?
Uh, so the purpose initially, my colleague Mythili did take us through. Mr. Harshal Patel, we will be sharing this presentation with all the attendees here. I request you can go through those slides, but in brief, there are multiple benefits of creating a trust, provided those are the purpose with which the settler is looking into.
Yeah, okay. Sorry, I joined this seminar late, so
No problem. So if I'm just putting across the initial slide here, I hope you can see this. The benefits, let me just a moment pull out. Yeah, this is an overview of the trust where it helps in succession planning, protection of family wealth, protection from future disputes, protection from for differently abled or special need children, and managing the assets in a structured way. And I'll also put up this slide which talks about need for a trust.
So is it mandatory to have this? Can we have a trust in the form of private limited company?
So trust is a vehicle created under Trust Act 1881. It's for income tax purpose. It is an association of persons. Okay. While private limited company is a separate entity which is formed under Companies Act. So these two are two separate entity structures. Of course, if you foresee that the benefits of the trust can be achieved through a private limited company, you can do so. But private limited company or a limited company has its own challenges. While trust is a pass-through entity, it can be structured as a pass-through entity. You cannot do it in a private limited company. So it has its own drawback for achieving these purposes.
Correct me if I am wrong. I think Tata has this private limited trust, right?
Okay, Tata Sons is a trust. I know that much. So I'm not sure if their trust is a private limited. Okay. We know that Tata has a trust. It is a private trust that we are talking about.
Yeah. Okay.
Yeah.
Thank you.
Thank you, Harsh.
Could you just sorry?
Yeah, Mr. Gangadhar, please go ahead.
It is again an income tax question. What are the implications of clubbing in case of non-recoverable trust? Are there any, if so? And the second question is that who has the right to transfer the property that is vested into the trust? Is that beneficiaries or trustee or settler himself? How can that, if at all somebody wants to transfer the property that is vested into the trust, how do you do that?
Okay, so let me take the second question first. That is, who can transfer the assets into the trust? Though we were talking during our webinar, we were talking about settler settling the trust assets into the trust. There are possibilities of other family members or others or third parties also gifting to the trust. It is possible. It is allowed. Like I, as an individual, can receive gift from anybody and everybody. Trust also can receive money or gift from anybody or everybody, and the tax regulations apply accordingly. So I hope I answered your second question.
My question is something different. Once the property is transferred to the trust, Can anybody again transfer or sell if they want to sell that property? How can that transfer happen?
Okay, so in case of trust, trustee is the person who manages the affairs of the trust. And if he feels that for the benefit of beneficiaries, the property has to be sold, then he has the authority to sell the property. Beneficiaries do not have the rights to sell the property without consent of trustee. Or I would put it the other way, trustee should generally discuss with the beneficiaries in the affairs generally. I mean, that is how it works. And the trustee will take a final decision. And he has the authority to deal with the assets of the property. So the beneficiaries alone, they cannot take a decision to sell the property.
So can I ask a question, sir?
Yes, Mr. Ganesh, go ahead.
What happens when there's a dispute between the beneficiaries and the trustee? Of course, the document will capture the arbitration or legal mechanism. Okay.
Right.
And suppose if it goes against the trustee, and the trustee itself is not there, then what would happen to the status of the trust then?
Okay. So there are a couple of situations that we can foresee here. One is due to fraudulent activities or due to differences between the trustee and the beneficiaries. If trustee has to be removed, sometimes the trust can capture the rights of beneficiaries to remove the trustee. Or if it gets into the arbitration and arbiter says that trustee is at mistake and hence he has to step down, a new trustee can be appointed with a consensus amongst the beneficiaries. That is possible. Alternatively, if the settlor has named subsequent trustees in the deed or through his letter of wishes, then those people will take the position of the trustee of the trust. And if nothing happens of this sort, that means the trust cannot find its next set of trustees, then the trust comes to a conclusion and it will get into dissolution and the assets gets distributed.
Lastly, I know you would have talked about will and trust and like other fellows. I also joined late for some other preoccupation. I see a lot of similarities between will and trust. I really could not see much of a difference. So maybe I missed out. If you could send the audio stuff also, I will hear that out. Or you can brief right now quickly.
We will share the recordings. We'll be putting across into the YouTube or we will share it separately. We'll do that.
But any quick observation on the will and trust, one-liner observation?
Yes, as Mythili mentioned earlier, we can always work in a combination of will and trust. While trust can be managed or set up for managing movable assets, immobile assets which are held by the person can be routed through a will into the trust post his demise. So apart from that, there is something called letter of wishes, which I mentioned briefly just now. The settlor can bring his wishes on certain aspects, like who will be the subsequent trustees, what happens when there are no more beneficiaries. Those things also can be captured in letter of wishes. It can be captured directly into the trust itself. Sometimes they prefer not to do so, and they bring it through a letter of wishes. So will, I mean, trust can be a replacement for will, or trust can be a complementary to a will. It can be, through a combination, it can be worked out for the better usage and effective, being made effective for the family.
Thank you so much. I look forward for the audio as well.
Sure.
Thank you so much.
One question, Mr. Arun.
Yes, sir.
You see, how many years will it take to get a probate of will?
Sir, we have heard from our lawyers that it may go on up to 6 months, and sometimes if there are complications, years together. But what we have heard from our lawyers is minimum 6 months.
Okay, that's fine. That's normal. Okay, one more thing is, suppose I decide to distribute my assets equally to my legal heirs, then why have a will? Why not die intestate? It'll be that much easier, isn't it?
Absolutely. I mean, as long as you're sure that your legal heirs will not get into litigation, or if you're sure that there are no third parties who can create issue post the lifetime, then please do will. Will is the simpler version. Of course, we went through the drawbacks of will. If you think that there are no challenges for your legal heirs in future, then you can stick to will structure only. Don't get into the trust structure.
Now, why have a will at all? Why not die intestate? So all they have to do is to get a legal heirship certificate and transfer the assets.
So as I said, already they will be in grief because of loss of losing the member, and going through the legal process before the court or the probate process is another headache for them. Yeah, you should know that even for the bank account to be operated, they have to get a certificate and then legal heir certificate, without which they can't even operate your bank account, sir.
So one other thing to add here with the legal hair certificate. So in practical aspects where we have seen is that see in those cases in where you have been located in a place and where you have neighbors who know you and who are your children, then there is a lot of thing where they say that you have to get so many people's inputs saying that so and so are the beneficiaries. Okay, so that is one of the issues that we practically see in terms of getting a legal hair certificate. And I have seen live cases where it is even 1 year and getting a legal hair certificate has been a complication, and getting sign-offs for that. It is more from a practical aspect where we say a will give an added benefit in terms of faster movement of this thing.
But can I sign an affidavit right now while I'm alive, saying who are my legal heirs?
So even then, your legal heirs has to justify themselves that they are the persons that you have mentioned in the affidavit. It is the other way, sir. From your side, you will identify the people, no problem. But for them to prove that they are the persons whom you have identified, they have to go through the process.
Sir, I beg to disagree, sir.
Yes, I mean.
I beg to disagree, sir.
Yeah.
So essentially, what the gentleman is asking is true. You can die intestate and happily. Legal certificate is relatively easy certificate to get it, and if you are able to today, to Aadhaar is there, earlier ration card, it's good. Even in will, if you go and have a will, also people can challenge that they are also legal heirs and they're disputing the will. That can happen. The only advantage of a will is that if the properties are not equivalently distributable, suppose there is only one house. If it's a legal certificate, all four have to get equal portion. There could be mother also getting a share. Then it becomes a challenge when you don't want anyone else except specifically the 2 people or 3 people whom you want to give it. In that case, will becomes beneficial. Otherwise, Indian Succession Act will come into play, which actually takes care of many other people coming in. Then you will require a release deed from everyone to sign the papers before you get the property in hand. Will remove the headache. Only probate is required only in 3 cities: Bombay, Kolkata, and Chennai. Other cities you don't even need a probate in a will. Therefore, will becomes easier when the properties are in all other places except these 3 cities. In these 3 cities, if will is not required, you need letter of administration any which ways, or you can go for a release deed, and you can go release deed is an easy option any which ways.
That is provided everybody is in consonance with it. Everybody is okay with what is there. Then it is a very release deed works in a better way.
Absolutely correct, sir. Absolutely correct, sir.
Letters of administration for my brother. Asked 2 years, I still haven't got it. And one more question, final one. You see, do we have to list out all the assets that I have in both the will and in the case of trust, so that the whole world will know, or can I hide it and say, give a general statement that these are without the amounts?
Sir, in case of will, you can always have a generic statement saying all the assets. You need not quantify, but at least identifying the type of assets also makes sense. However, in case of trust, again, you can start the trust with a minimal amount as a settling the amount even 10,000 rupees depositing into the trust is sufficient, and you can transfer the assets subsequent to creation, so that there is nothing documented in the trust deed.
Okay, that's excellent. Thank you. Thank you so much.
Thank you. And I request Vijay Simha to roll out our feedback poll. Dear members, request you to spare one more minute and provide your feedback about this webinar. This will help us to improve ourselves and come up with similar webinars in future. And of course, our time that we had taken was 1 hour 30 minutes. But due to the nature of the topic, we have overshot. I sincerely thank each one of you who have attended this webinar. Heartfelt gratitude to you all, and I hope the session made some value add to you all. Thanks a lot.
Thank you all so much. Thank you so much, Arun. Thank you for supporting through.
Thank you. Thanks.
Thank you.
And thanks to our team also. I mean, I should recognize their effort in making this
Maybe
successful.
the one in the back end who's actually supporting us through. Thank you so much, Sima. Thank you, Shraddha, Aditya, Aman. Thank you so much for this.
Thanks, ma'am.
And not
Thanks,
to
everyone.
forget our IT team, admin
IT
team.
support, Dinesh,
Yeah.
and yes, certainly Dinesh and Suresh as well. Thank you so much for this.
And
Thank you
thanks
all.
to,
Have a lovely evening.
yeah, thanks to other divisions also here who have invited their guests, clients to attend this session. Thanks a lot.
Thank you. Arun, thank you so much to you and your team.